call the Honourable Michael Woodhouse.
Oh, thank you, Mr. Speaker. It's my pleasure to take what I expect will be the final call before the vote in the third reading on the Employment Relations Amendment Bill, and I want to acknowledge my friend and colleague Fisita Senlotuinga for moving the third reading as I was unable to do so, and I appreciate the Whip's indulgence for giving me this final call. Mr. Speaker, this afternoon it was my great privilege as Minister of Police to attend my first graduation ceremony at the Royal New Zealand Police College in Porirua. And I want to congratulate those graduates of Recruit Wing 287, and they are now sworn members of the Constabulary in New Zealand. Now, there's a very interesting thing about the New Zealand Police, Mr. Speaker. Those men and women in the New Zealand Police Force are not allowed to strike.
You're a very powerful union, though.
In fact, this House legislated against the right of those workers to take industrial action. Now, what this House also did was it provided for some flexibility, for some compensation, for processes for mediation and arbitration in the event that negotiations between them and their employers became protracted. That's the same with the New Zealand Defence Force and a number of other organisations in this country. It is sound, it is sensible, it is flexible. And do we hear the wailing and gnashing of teeth about that kind of flexibility on the other side? Absolutely not. So what I completely fail to understand is why the very pragmatic, sensible, flexible arrangements that are being proposed in this bill are being so opposed by the opposition. And Mr. Seymour, in his first intervention on this bill, has rather quizzically seen that very moderate changes in his view are getting what he thought, I think, was an overreaction. Well, I think Mr. Seymour needs to get used to that, because that is the nature of the industrial relations landscape in this House. Because even the most moderate, sensible, flexible changes will be railed upon by the opposition. And we have seen that throughout this debate. And for generations, similar types of practical accommodations were able to be made where the circumstances required them. And we've mentioned the sorts of things, the night shift nurse in the aged care home, the supervisor at the 24-hour service station, the sole charge air traffic controller at small airports. Very practical solutions which were made unlawful in 2008 by the amendment to this Act. And we've heard a lot, the bus drivers urinating in bottles, the very important conditions that Mr. Twyford describes in the forestry sector. Those sorts of things are unlawful now, and they will be unlawful in the future, Mr. Speaker. And what angers me about the tub-thumping rhetoric by the cloth cap wearers in the opposition is that their irrational and incorrect description of the flexibility as the arbitrary removal of tea breaks has created a climate of fear amongst hundreds of thousands of workers in this country, the very workers they claim to represent. And for that, Mr. Speaker, the opposition should be ashamed. Now, I want to turn now to the duty to conclude the duty of good faith, not requiring a duty to conclude collective bargaining. And I want to thank the architects of that clause, the fifth Labor government, who introduced those provisions when the Employment Relations Act was passed in 2000. It was sensible, it worked, and for reasons which the National and ACT parties in opposition could not fathom, was removed in 2004. Well, we're putting it back, Mr. Speaker, but we're doing more than that. We are creating very good provisions for the prevention and control of what is called surface bargaining, which can be conducted not just by the employers, but by employees and their representatives. The Employment Relations Authority has to be satisfied that good faith has been undertaken before a decision to conclude the bargaining process is made. And of course, that for 60 days at least prevents the right to strike. It also prevents the right of an employer to lock workers out. It goes both ways, Mr. Speaker. And finally, I want to talk about Part 6A. Now, as a rugby referee, when one comes off the field and both teams are pretty unhappy with one's performance, you think you've done a pretty good job. And it's certainly the case with Part 6A. The unions are unhappy, the employers are unhappy with what are some moderate, sensible changes that I think will actually support the type of workers that support the Labour Party. And Mr Hipkins in his intervention asked, and I paraphrase, what stops a company like, say, Spotless from structuring their business to create a means to get around Part 6A? Well, he clearly hasn't read the bill, Mr Speaker, because exactly those provisions on effective control of franchise arrangements to prevent such structuring have been put into the bill. And it's also noteworthy that those genuinely small organisations, and about 75% of the organisations, say in cleaning in this country, are sole practice or very small family-owned businesses that do not have the means or the wherewithal to embark on the responsibilities as set out in Part 6A, often migrants, workers who have been cleaners themselves, who have set up their own business and are struggling to make it work, and who are successful in getting new tenders and should be protected from, I think, the obligation, the burden that would have them comply with Part 6A. Very sensible, very practical, and I think appropriate changes to the Employment Relations Act, Mr Speaker. But as I say, Mr Seymour, I think needs to get used to the fact that even sensible changes to our employment relations and ACC legislation will have the opposition up like meerkats. But I support this bill. This is good for our employment relations landscape. It's good for employers, it's good for employees. Mr Speaker, I commend it to the House.
Point of order, Phil Twyford.
I seek leave of the House to table the pay slips, employment contract and daily timesheets of Charles Finlay, a forestry worker who died at work.
Is there any objection? You have permission? Just checking, you've got permission? Is there any objection? There is no objection. The documents will be tabled. The question is that the motion be agreed to. Those of that opinion will say aye. Aye. To the contrary, no. No. The ayes have it. Party vote is called for. Clerk will conduct a party vote.
New Zealand National.
60 votes in favour.
New Zealand Labour.
32 votes against.
Sorry? Could we have that repeated, please?
32 votes opposed.
Green Party.
13 votes opposed.
New Zealand First.
11 opposed.
Māori Party.
2 votes opposed.
ACT New Zealand.
Vote in favour.
United Future.
1 vote in favour.
Any other votes?
The ayes are 62, the noes are 58. The bill will be read a third time.
Employment Relations Amendment Bill, third reading.
Call on Government